Hi everyone, Harry here to talk about the state of play of the New York case, which had been scheduled for sentencing next week, June 26th. That won't be happening, but it's a little bit unclear what will be happening. So you have a report in the New York Times today saying that the DA has acquiesced in or argued to the court that sentencing should be put off until after Trump's second term in office, a mere 216 weeks. I think we should have a calendar that we take off with every week. That's just wrong, and I don't understand how the paper of record did that. Here's what's actually going on. So yesterday was supposed to be a big hearing. At that hearing, the DA was supposed to give its thoughts for how to proceed with everything. In lieu of that, the DA did submit a letter. Now, there's already a motion for new trial pending based on Trump's argument that the jury improperly heard testimony that is immunized under the Supreme Court standards, and that testimony was with Hope Hicks after he was president in March, when Hicks came in with the story that the Wall Street Journal was going to be covering the whole Stormy Daniels scandal. He said, hey, the jury heard about that. That was immune. Not clear that it would be or not. That's one of the things to decide. And that would be error that tainted the verdict. And that, I think, as I've suggested before, will be where Merchant goes, saying even if this was a problem, it was harmless error. There's all kinds of testimony that went to the relevance of the testimony with Hope Hicks, which is how much they worried about it and how they cared about the Stormy Daniels revelations and the like. Okay, but that was pending, and we know that Trump wants to do a motion to dismiss the whole thing, just make it go away, based on it had been immunity, but it looks like possibly it's some combination of immunity and the fact that he is ascending to the presidency, and some argument about how just its mere existence, maybe even its existence in the past, and the black mark of 34 convictions would somehow impede his effectiveness as a president. And we're going to have what, that's obviously never having a president felon before, that would raise some newfangled issues. In fact, I'll talk to them about those in a little bit more in a second. But to finish out the procedural hand here, the DA comes in and said, all right, look, we understand this sentencing won't take place next Tuesday. Even if we say it should and you agree, Trump, will take an appeal to the New York Appellate Division, the New York Court of Appeals, and the Supreme Court, and he's going to be able, it's almost poignant that they are the prosecutors, the state power, and saying, oh, we're never going to be able to make this happen. So fine, forget about the sentencing next Tuesday. However, don't forget about it, period. Trump wants to do his motion to dismiss. Let him do his motion to dismiss. Make quick work of it, in fact, if you can. And we would like our response to that, which we disagree with, for you to receive December 9th. And they're setting out a calendar that's a little bit quick, but it would permit Merchant to adjudicate the motion to dismiss based on immunity before Trump takes office. Now, the sentencing is a whole different matter. I mean, I think he could easily have proceeded to sentencing next Tuesday and nevertheless considered Trump's motion thereafter. They're not linked. You could imagine imposing sentence and then deciding, or a higher court deciding, because of immunity, the whole thing should go away. Or you can decide, doing it in the other order. But in any event, they're not inextricably linked, but the DA is kind of nodding to the practical exigencies that everyone is seeing, including, I think, Mayor Chan, and saying, all right, do his motion, but then sentence him. And they make an interesting point. We know that it's fine for a sitting president to have to face a civil lawsuit. That's Bill Clinton and Paula Jones, and the court talked about how that wouldn't really get very much in the way of the presidency. We know that it's the Department of Justice's view, but never confirmed by the courts. Little sort of footnote in the immunity case on this, but definitely not a holding, that a sitting president can't be subjected to a whole criminal trial, which is really onerous and consuming. I mean, we saw Trump in the New York trial there every day. You know, he could hardly have gone through that at the same time as he was doing presidential duties. But that's happened now. And the jury verdict has happened now, and there may be appeals, but they don't really take up his time, and they're nothing more special than a civil appeal would be. And the DA says, look, you know, when you have just a post-trial proceedings, including imposition of sentence, there's no reason that the Constitution can't abide that occurring to a sitting president. So that sets up a potentially big time issue that could go to the Supreme Court. It is true, on the one hand, as a matter of sort of practical imposition on the office of the presidency, you know, a court date where he hears, okay, your sentence is blank, not a big problem. And, you know, he already comes to office, is elected indeed as a felon. Now, on the other hand, if the reason behind the special, you know, president only suspension of criminal proceedings isn't, as it seemed in the civil context from the Supreme Court opinion in Clinton v. Jones, it is not the practical problems, but some broader thing, and that will be the argument, like, how's he supposed to deal fairly with New York when this is over his head? Or how's he supposed to be in the international setting when he's a felon who ends his term, in theory, absent some other coup or whatever, by a little trip to Rikers Island and the like? That's going to be the kind of argument, and it's an interesting and unresolved legal issue. So what the DA is saying is, do Trump's motion to dismiss first and then proceed to sentencing. Now, that's an implicit concession that if Mayor Chan grants Trump's motion to dismiss the whole case, then he won't proceed to sentencing unless that's reversed by the appellate court. That's it. Case is over, and it wipes it off the books, which is what Trump dearly wants to do. And I do think Mayor Chan, who had a pretty firm hand in the court and the trial itself, has shown himself to be attuned to, sensitive to these political issues that Trump has put into play because he's won the presidency, and maybe not wanting to get reversed by higher or the U.S. Supreme Court and the like. So I think he's a law-abiding judge, but if you just think about that consideration, it might lead you to, for example, grant the motion to dismiss on the immunity ground, or deny the motion to dismiss, proceed to sentencing, but pronounce a sentence that is really pretty tame, like, say, only a fine, and that, in effect, while the case stays on the books and the convictions and all those things, subject, of course, to his appeal, he can take up whatever issues on appeal he thinks he has. But it's the sort of thing that a fine, you write a check, and there's no argument that it has some kind of continuing drag on your duties as a president. Even probation which I think would be expected in this case, whether or not a jail sentence is imposed, prison sentence is imposed, even probation, you can argue, entails a deprivation of liberty or a kind of sword hanging over the president's head, as it were. A fine might not. So if Merchan is looking to kind of discretion be the better part of valor, or in this setting, what you could imagine his doing is either granting the motion to dismiss or denying it and then proceeding to a sentence that in effect ties up the case, finishes it, but doesn't extinguish the actual record of it. If I had to bet, that would be my best guess. I don't feel, and I don't shy away from predictions, as you guys know, but I don't feel strongly about that because everything is kind of up in the air after the election in general, but with Merchan in particular. And of course, if he goes that route, if he denies the motion to dismiss, I think you may have Trump trying to yank that up on appeal and at the same time try, though, as I've said, it doesn't follow that he has a right to do this, but try to keep the sentencing from going forward, try to get a court of appeals that's considering a denial of a motion to dismiss to at the same time grant a stay as to actual imposition of sentence. All this is likely to play out with President Donald Trump. That is, given Bragg's acquiescence to doing the motion to dismiss first, I think even a fairly quick schedule will have that adjudicated, maybe before inauguration, but all this other stuff will be after. So it'll be this ungainly, awkward, anomalous situation of a sitting president potentially having to deal with a criminal case, but those are part of the unprecedented circumstances we find ourselves in. Not simply that he won, but he won after a presidency and a post-presidency that was something of a crime spree, most of which is being now vaporized by a combination of good luck and constitutional doctrine. But there remains this one detail that, may or may not get swept away. So that's what to look for. First, how Merchan deals with the motion to dismiss. Then if Trump is able, if Merchan denies it, if he grants it, we're done, I think. Maybe a court of appeal would reverse if the DA appeals, but, a lot of sort of momentum not to. But if Merchan denies, is Trump able, while appealing that, to put the sentencing on hold? But if not, and sentencing occurs, what will Merchan do to potentially, protect the case overall, but not trigger a whole, year and a half of litigation potentially going up to the U.S. Supreme Court? And one way to do it would be, say, to impose a fine and nothing more. It's all, as Bragg himself put it in the letter, unprecedented circumstances with a welter of political and legal considerations at play. But at a minimum, no sentencing next week, and instead adjudication of Trump's, he hasn't even filed it yet, but expected motion to dismiss on grounds of immunity, saying you shouldn't have brought this case in the first place. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.